the year after we got it, after we left office, then they got that law passed. But that's another little burr on my saddle. So.
Well, I agree that the expert needs to help people do that. I think since we hit noon, I'm going to go ahead and begin this quarterly conference call. Thank you all for being here for the LifeCircle quarterly conference call. And we have another, what I anticipate will be another excellent conference call. So to introduce our speaker, Mary Perrineau will do that. Thank you, Mary.
Thank you, Dr. Eisness. And just so you know, there are some people on the phone, and this will be recorded and sent out to the Palliative Care Network as well. So I know there's a lot of interest in this topic, and I thank Matt for providing this information for us. It's very valuable information. I really feel not capable of introducing him, so I'll tell you what I do know, and he may need to correct anything I say.
Well, let's just not do it. Let's just skip over.
I'll say two things. I know three things. I know he's a nurse, I know he's a lawyer, and I know he's a good guy. So we'll let him take it from there, and I'll let you tell more of your history, Matt, so that you can share how you got to this point in life, and I'll let you take it from here.
And could I interrupt? I apologize for the interruption, but Matt, my name is Cameo Anders. We also have some people joining us from the Elder Law Community Committee, possibly. So just so you know your full audience, I thought that in case you're still mad about the financial power of attorney things that have gone down, you might have someone in your audience that can help you out with that.
That's awesome.
Okay.
And it's nice to finally meet you in person instead of email, Kenya. That's great.
Yeah. Nice to meet you, and I apologize for the interruption.
Oh no, I appreciate knowing the audience, and I have to say, this is one of the topics why I went to law school, and I went to law school after nursing school, and part of what I had experienced growing up is with a mother who was mostly a single parent, and my dad leaving is the world that I got honored to be in healthcare, with a lot of mentors and overwhelmingly women who had difficulties, and we had difficulties in who could make decisions for whom. And it wasn't really something in school that was taught, but became very complex, and even is more complex now. And interesting, the history of surrogate decision makers, I'll just jump into it. And I was a Navy JAG, and so the decisions on a federal level, if you're in a federal environment, will be different, especially for the students listening. And obviously, if you're overseas, depending on your jurisdiction, that will also be different, because our society has a different sort of what I would call hierarchy of decision making. I will stick with our states in the upper Midwest, where I predominantly have practiced over the years, and start with the principle that surrogate decision making, as a number of you are aware, is something that's relatively new within the jurisprudence of the laws. And most law was started by men, controlled by men, in industries and organizations that were male dominated. And what you would see is, and I experienced it, I know Dr. Eidsness did, even in my clinical experiences early on at, say, the Human Services Center, a number of women were dropped off by husbands, and people were given diagnoses so that, it's not that the individual didn't have an illness like anxiety, depressive reactive disorders, which we would call it now, pre-Klonopin and all those. But it was male dominated, and therefore, almost chattel, as we would learn in law school. Those laws dramatically changed in terms of the authority of people to make decisions, simultaneously with warehousing people, both developmentally disabled as well as behaviorally disabled. And we've experienced that in South Dakota. We're not isolated from that at all. And when various movements came through, laws about who actually could make decisions for somebody, and protect them have come into place. Within the healthcare realm, what I always do, just because it helps me, and is think about my own life and the people that I'm able to make decisions for. So I have an 89-year-old mother. I happen to have her power of attorney for healthcare. But if I did not have that, it would be a hierarchy under the Healthcare Consent Act that Dr. Igenis was very involved in establishing in South Dakota, and others on the call. And so it would be her children, and there are 4 other children in my family. We get along, but normally that's not true. There's usually somebody, as I joke, who comes in from California to explain to us how idiotic and stupid we are in backwater thinking. And that's a mess at the bedside. And so we have that realm of having powers of attorney. And of course, you can have those for business and for healthcare purposes. And so when I think about it in my own lives and getting to the topic of guardianship, Karen, my wife, and I, if we think about our various lives, I have a sister who has a special needs son who had traumatic brain injury as a young child, who's in Redfield, but he's had a rugged life, and they have 2. And they have a guardianship over him as a developmentally disabled adult, meaning that they get to make healthcare decisions for them. In my life, my wife and I have, and I think Justin advanced to you, one guardianship left. We've had a couple of others of people that we love. And this young lady's name is Bev Christensen. Her parents are now both deceased. We were their power of attorney. And when Beverly Ann is one of 2 children, one who died at 15 years old, but both parents have the genetic gene for PKU. And so she's a rare individual. I know Dr. Eisnes would have seen PKU, but she's one of these rare individuals that still is alive and has PKU and functions probably at a 5th to 8th grade level, was in Redfield, et cetera. And so one of the important things that I always talk about is who gets then, we're going to concentrate on guardianship, who gets to make decisions for Beverly. And the guardianship process can be adversarial, especially if there's land and a lot of money involved. I'm going to talk about the simple one, and Bev is a real good example. The process for guardianship is involved. It should be. It's expensive, and it is in a small lowercase a adversarial. What I mean by that is the person bringing the petition needs to demonstrate that Bev really can't make decisions for herself. And in going through that process, we'll talk about the statutes specifically, but the petition has to say that the individual is incapable of taking care of herself and making these kind of decisions. And then it needs to be supported by a physician, her physician, or an independent physician. And third, which is something I've truly enjoyed in my life, the representation of the potential protected person. We used to use the word ward. That representation has to be through legal counsel. So if you think of places where you live, like Achieve, where Ability Building Services, any area where it has community support groups, those folks, at some point in time, maybe they've got a guardian. Obviously, a lot of times you do, but as children matriculate out of at age 21, that happens a lot. Or maybe they've not needed a power of attorney, a guardianship for anything. And so I will act as the lawyer for the potential protected person and interview the individual who's got the developmental disorder. Now, mind you, it's more difficult when there's when we are talking about issues relative to behavioral health, and these can be pretty contentious again in a situation where there's a lot of money, but not a current long-term disability. So what happens then is you go through the court process, and this is something, especially for students that are listening to this, that when somebody says guardianship, words mean things. Words mean things. A guardianship is over the person, the ability to make decisions for somebody else. So the form that comes out, and when you're at the bedside, it happens all the time. Mary and her team will call me and they'll say this doesn't happen very often anymore because they've already done their investigation, but they'll say, we have this individual and this person showing up saying, well, I've been her guardian for 20 years. And it's interesting because their caregiver, wherever this was, said, yeah, she's the guardian, but they don't have any court document of it. And you just got to have that. And it's not that I don't distrust people, but you'll get people, as an analogy, saying, and I'm emancipated. Well, I've only seen one emancipated minor in my life from a paperwork perspective, actually jumping through it. Or I'm her husband, common law. I mean, we've all, when you think about those things, just those representations, that's what they have in their heart. They may not have the legal background backing for it. So the documents called the letters, after you've gone through all these, they're letters of guardianship that would show up. And that's the example that I have in your documents there that shows, Matt and Karen, individually or together, can make healthcare decisions for Bev. The second piece of this, and Bev, by the way, is 76 years old, kind of an absolute miracle. And the second part of that is we petitioned to be her conservator. So a guardian is over the person. In case you're on a game show, conservator is over her money. She doesn't have a whole lot of money. She's on Medicaid, but we'll talk about the statutes in a bit and make it come alive for Bev Ann, who can articulate her wishes. But when we look at somebody at the bedside saying, doctor, I am her guardian, there must be these letters of guardianship. And usually it's letters of guardianship and conservator. When they come from tribal courts, they may not say conservator, don't care about that because these are healthcare decisions. And, usually it's not a guardian that's willing to sell property or something like that. So in our world, I'm continuing to narrow it, that it's obviously for healthcare. By the way, there's been a lot of additional work done in our state over guardianships requiring education. So Karen and I have to take the education for that and get certified. It actually, again, is a court process with Bev. And her parents actually, originally I represented Bev and then couldn't when her parents obviously became infirm. But we went to court and Beverly enjoyed that and told the judge, yeah, I'd like to have them care for me. And so it's, again, not always adversarial. So turning to the statutes, and then I'm going to leave plenty of time for questions. I hope I'm touching on the topics that are the most important. But we have two worlds of statutes. One is this creation of the guardianship and the demonstration of the proof, the burden of proof, we say, as Cameo would teach this to students. You've got a burden because you're the ones who are saying, I've got to protect Bev Ann. She's incapable of making decisions for herself. And the law says that's true, but you, Matt, and Karen need to prove in the statutes that she doesn't have the ability to really respond to people, events, and make decisions in her own. And it's impaired, and the language is impaired to such an extent that they lack the capacity to meet the essential requirements for health, care, safety, habilitation, and therapeutic needs. So that's what the judge, she would have to determine that Bev Ann indeed does not meet that. And again, you present a letter from the physician. I represented Bev Ann indicating that that is correct, and that her mom and dad would be very good guardians. And so then it goes to, well, what's the responsibility? What do now, in this case, Matt and Karen have as responsibilities to Bev? Well, we are to make decisions in the second statute regarding the protected persons. Again, that's our modern word for what a lot of us would have referred to as a ward, protected person support and care, and if not inconsistent with an order of commitment, which would make sense. So if there was a behavioral health commitment or an alcohol and drug abuse commitment, that would overrule the guardianship. And we've had that happen before with my nephew, who was very violent, and we would have those kind of circumstances. And so you would have committals. And to the extent that he would calm down, then you would go back and forth. Is this an involuntary? And if not, at this point in time, can their parents as guardian ask for voluntary admission? And that's something that would happen periodically in these tough cases. And so then the next statute talks about the responsibility of a conservator. I won't spend much time on that, but it's obviously to spend the money on the care of this individual. And there are annual accountings we complete with the lawyer that represents, because I would have a conflict of interest, so I don't do this. And we do an annual accounting and a report to the court indicating that she has $2,000. She's on Medicaid, so we've got to keep it below that. And that she now lives in a nursing home and what that care is all like. So if you went back to all the reports over the years, you would see how she's progressed from essentially being on her own with care and then having various health issues that have brought her in and out of healthcare organizations, with decisions being made by first her parents a number of years ago, and then Karen and me. Along with then the next statute is, the interaction with family, which she has, but also the presumption then, as we turn to other statutes, of making healthcare decisions to the extent that you can think that they would be appropriate. And I want to ramp forward then to how guardianship and the Healthcare Consent Act interplay. And it was something that was intentional when Dr. Eidsness and a lot of folks got together originally to put this statute together. And it is called the Healthcare Consent Act. I have a tendency to refer to it as 3412C because it's sort of the grandmother of a lot of statutes that came in that section. And we run to that statute quite a bit in supporting physicians in health law. And so Mary will call, or somebody from the emergency department will call, and you just say, hey, we have an individual here who does not have the capacity to make a decision for himself. And we've got this fact pattern, and they'll lay it out. And I will tell you, it's still very rare that a call comes like that says they say they're a guardian. It's mostly the other circumstances that we're involved in, again, because this is a high hurdle to get over with the guardianship. I'll repeat, if they say they're a guardian, we need the papers. If they say they're a power of attorney, we need the papers. But the statute that I've highlighted, and the reason I yellow highlighted that is that actually it's a nice meshing for you as providers or individuals supporting it, because it's saying that a healthcare decision can be made by under this chapter for an adult person if they're incapable of making that decision for themselves. And therefore, a person is incapable of giving informed consent to healthcare if he has a guardian that has been appointed. So you just stop there and you go, well, if we've got letters of guardianship with Matt, obviously it's a woman. We don't have to go through, Dr. Eidsness needing to make a decision that Bev Ann is incapable of making decisions for her, and then we have this bedside fight. What I really historically, and why it's such a privilege to be with Dr. Eidsness, is this statutory language received very little pushback as it relates to the immunity. And so I continue to use the fact pattern with Bev Ann. And let's say she has an advanced case of Parkinson's. She has dysphagia, which means she can't swallow very well. And she was a savant for many years. She knew exactly my date, a day and date of my birthday. And we would always talk about that, or say 50 years ago, she was in Oklahoma and this is what was happening. just an amazing woman. She has deteriorated to the point where she can't do that as much, and this dysphagia is more problematic. It would not surprise us if, in knowing that she's a very religious person, she's seen her mother and dad pass, and she believes in the afterlife. And so she talks about seeing her brother and mom and dad. And so we've got decisions to be made in a circumstance that may or not be appropriate, and the doctors and all of us talk about it. And then the statute talks about, it could be that the physician doesn't agree with some of our treatment requests for Bevan, but we know Bevan, or we agree with it. And if we're talking end of life, we know that palliative keeps her comfortable. We also know Bevan doesn't experience pain, physical pain, like we do. It's an amazing neurological gift, and has been a problem in the past with foot sores. And so one of the most powerful statutes, you would think, well, I should hang out, for students again, I should hang out and look in the guardianship statutes. You would not be able to find and cross-reference this very well without going to your healthcare statutes. It's not cross-referenced very well, and in the way that we do that electronically anymore with statutes. It's not like I'm old enough if I pull the book out and you can see some good cross-references. And so I'm going to suggest to the students that you keep track of these kind of cross-references in a binder and in a grid. And I was taught that early on, almost 35 years ago, from one of my legal mentors, because I wouldn't be able to cross-reference it. And so you get to 3412C7 and say you get a call as a physician or as a palliative care provider or as the healthcare lawyer for these individuals saying, Michels is wanting to make decisions for Bevan Christensen. We've got these letters of guardianship. She had an aspiration. She's had antibiotics, really is not reacting to it. It is reasonable to withdraw care and give palliative care, but we're kind of concerned about our liability. And you would go, well, first of all, I want to see the letters of guardianship. Is Matt able to make that decision? And are he and his wife in agreement? Yes. Secondly, does it make medical sense? Well, it does. It's reasonable. And then you go and you give what I would call the blanket of comfort, which was the intent of this statute in healthcare consent. But again, you wouldn't find it without your own personal cross-reference. It's difficult. And that's in 3412C7, that a healthcare provider, so I'll use Dr. Eidsness, acting or she declines to act in reliance on our decision. So she could disagree with us and say that that's not accurate, and that does happen, or you sense an ulterior motive. That happens. And the statute of immunity is broad, that she would not be exposed to any criminal prosecution or civil liability, which mean lawsuits, or her professional board couldn't bring any action. And especially if the individual, if you're relying on this in good faith as to the individual having the ability, that is Matt and Karen, to make the decisions for Bev. The other nice thing is the bottom of that statute says that this is reasonable. Palliative care, I never heard anything about it. We've loved Bevan for close to 30 years, but she should be comfortable. That's what I understand, is make her comfortable. We don't want her to have any pain. We just want to sing to her and talk with her as she listens and transitions from this life. And it says, hey, if I'm able to make informed decisions based on this in this chapter, which includes somebody who has a guardianship, then I am, Karen and I are both immune from liability. If maybe one of her distant nieces, she doesn't have a whole lot of relatives, cousins, would bring action. So we've got that interesting piece of immunity. And I like how these two interplay, and it really is rarely am I asked to talk about guardianship. So it's an absolute privilege to do that. And so I wanted to leave some time for questions. I'm sure I've missed some things that you wanted me to cover, Doctor, or if there's students listening, Cameo, they want to, stump me, it's easy to do.
Matt, thank you, because this was informative to hear on the guardianship. One thing that I had always been under the impression, and I don't know that there's any fact to this, but the impression that getting guardianship isn't easy, especially if it's a non-family member. So we've had patients in hospital who lack the capacity to make decisions, and yet there were no family members either available or heard of when a patient was capable of making decisions, would decline to have any family members listed. So now the patient is in hospital with no one to make decisions. And our approach has always been, do what's medically appropriate as we continue to look for someone. But back to the question of, in situations like that, difficult to go to the court and get a guardian. At least that was my understanding. So I don't know, thoughts on that?
It's incredibly difficult and
What
expensive.
should we do?
Yeah, it's incredibly difficult and expensive, and it should be. I'm not gonna, there's these two universes, the facts, that pattern that you have, and then more and more people just don't have loved ones around. They're ornery individuals who just left the world, or their families peeled out. And it's difficult to, regardless of how good the people are at the state, it is not easy to get the state to step in either, and for a lot of reasons. So that's why we appealed to, and you helped a lot of people, led to the, a close friend language in the Healthcare Consent Act, because that really has solved a number of issues, like there's a neighbor, and that, along with immunity under Healthcare Consent Act. And that's whenever I'm called about, can we go to a guardianship? I go, let's find a best friend, or can we find a niece somewhere? Just somebody, because that court process overwhelms the issue of caring for the human.
Yeah, well, I appreciate that input, because that's, I think, what we tried to do. And as you know, the close friend was added in 2007 because of similar clinical situations where there wasn't anyone. And so that does help. Although I know there was a lot of concern on the judicial committee of how do you define close friend. And I know several were concerned that we'd just find someone walking down the hallway that claimed to be a friend. But I've not run into those kinds of concerns, at least on a clinical basis.
It really has been invaluable. I mean, when we were working on it in the committee and you all brought it, there aren't that many individuals using your fact pattern. That's what I would tell people in the halls is, are you going to walk down the street and go, hey, I want to make decisions for Matt, I hate his guts? Maybe yes, but it's not like there's a whole lot of people hanging around going, oh, I'd love to go into an ICU and make decisions.
Yeah.
So
Usually we can find someone. Well, sometimes not. I can think of a couple of situations where there's no one. So the approach that was taken often for people who have burned all their bridges with family and friends is to still do what's medically appropriate. What would another person do in this situation? Does that seem okay?
absolutely. And the immunity language has stood the test of time. That it doesn't necessarily mean people couldn't bring lawsuits, but I've not seen, since we put these laws in place, any claims like insurance claims, any lawsuits, et cetera. And I have to say, I think we as a society are getting more cantankerous in the upper Midwest as we find, just as society changes. And so I've encountered some really strange and very combative situations much more in the last few years. And I'm not going to point to reasons, it's just factual. And, but when we get to these kind of circumstances, the ability to communicate what's logical is just perfect. I will tell you what I have encountered, and it's something that occurred in a lot larger places for a long time, is people that won't get individuals to move out to a different service. So especially in behavioral health or a longer term service, trying to find a placement, and family members or whomever won't agree to it. And, so it's a different kind of battle than palliative care, but I'm off topic. And it'd be very beneficial, in these circumstances way in advance to try to get streamlined guardianship. I know in some circumstances it's not easy, but when you look at the pro se work that's done in pro se means individuals coming to the court themselves, and the elaboration of that, Mike McKnight there and a number of people in the Sioux Falls area started it for like divorces, and you can do those type of things. This would be a natural extension. And I know Cameo and others through the law school, unlike when I went through law school, it was so different than my healthcare experience, because you really didn't have watch one, do one, teach one from a healthcare perspective. And now there's much more experiential. I've had externs. Cameo will have their students interview people, her students, to try to see if they like it, taste entrees on the smorgasbord. But I do think that the fact that it's harder to do guardianship pro se is the protected person could be harmed.
Oh, thank you, Matt, for this, for just the presentation and your willingness to, speak to a wide audience. One thing that I'm super grateful to the LifeCircle group for taking on is an education piece for guardians. So part of what I do is sit on a committee, the Elder Law Committee is retooling the guardianship education requirements, if that would be a correct way to say it. So, and then the LifeCircle has taken up the task of how can we create a better understanding of healthcare decision-making for guardians. So with that, sort of trying to create that bridge, do you have any advice or recommendations or maybe pieces of education regarding healthcare decisions that would be really important for new guardians to have?
From our collective healthcare experiences, it's a powerful question, because if you're exposed now to a number of students with different experiences, but still the vast majority of them are coming from school, right? They've gone through, and so they're not all non-traditional. And I think it's very helpful if you've got individuals in the group who have healthcare backgrounds, and you can have them bring up fact patterns. And just what I tried to do was, let's go ahead and be real and vulnerable about it. I've made decisions about individuals in my family, my grandfather, I can get down the list, that actually did, they were good decisions. They were ones that he wanted me to make, I knew, before he became incompetent. But I'm not here in a way, as I would give seminars, regretting or feeling bad these last 35 years from when I made that decision that it was right or wrong. I knew it was right. And the only way we do that is demystify. And that is to talk about these cases, come in, if nobody's seen, as obviously harder, but if nobody's been to an emergency department or intensive care, I mean, they're amazingly intimidating environments. And we just need to walk through, this is what will happen. It would be nice to know. in advance if you know what your protected person would like in those circumstances. And again, they're tough decisions, but we got a lot of people to support it. And I think whenever I've done this Cameo, and I know you have too, you'll get individuals from elder law. And I would ask, I think we've got deeper issues with what I would call developmental disabled individuals because their parents are dying. We have more of state involvement, and thankfully we've got great lawyers that work for the state, but we could throw the blanket over this whole decision-making process through a guardianship. And how is it I make a decision for somebody as the guardian of my cousin, and he has never been verbal? And you give those kind of fact patterns. He's never been verbal. He's 60 years in a wheelchair, cared for in different places. And now he's aspirating, looks like he's got COVID. What should we do? And you could throw COVID in there, but that gives kind of the exclamation mark. But what I will say is that, that sort of element of it is, I think, something that we all have to think about. It's sort of a rambling answer. Is that anywhere close to something you were looking for?
Yeah, no, definitely. Thank you. And I'm just hearing those fact patterns as being super useful. So I appreciate that, because then maybe I can reach out to the group, excuse me, and have you be thinking about fact patterns that we could offer as educational tools. But yeah, so thank you for that.
Well, of course, you have a great network now of individuals who are lawyers or in law school that have clinical backgrounds, and they can just throw, this is exactly what happened. And I haven't been in the bedside in a while, but I can tell you with these loved ones in the last 10 years, I've got plenty of good fact patterns. Having to hog tie my friend Beverly's dad, he was a real difficult challenge in the last couple of years, and having to tell him, order him. When I was in Pier, I got on the phone with him and ordering him to knock it off. Okay. You just, it's the relationships, I guess.
And I think that's part of the challenge with guardians. You as guardian for Bev, her, many of the guardians that I've met through the years of practice, they may have seen their person, their guardians for once a year, and they don't know the person. And so when they were down to making decisions, really hesitant to make them. And we understand that if you're talking about withdrawing life support to allow death to occur, they aren't going to go into that decision lightly. But it almost seemed to get to the point of being paralyzed to even make a decision. And I know in Minnesota, when we'd work with the guardians, we were even told they had to go through the Secretary of Health. Now I've been out of clinical practice for over a year, so that may have changed. But there's such a hierarchy of getting permission to make decisions, it seems. So it's just a reflection, not necessarily a direct question. But if you have any thoughts on that, how to help guardians who don't know the patient.
The nice thing is if you have circumstances with palliative care, which has been the passion of you in this group for a long time, is to reach out to community service providers like Achieve and those organizations, Children's Home, all of those. And I think that just like way back when, Doctor, when we would put on end-of-life seminars, how a power of attorney would work or not, that really people would be in tune to that, to demystify it in a kind of Zoom conferences for individuals that the community support providers organizations that be put together. There are, by the way, in our state, and I know you've got plenty of governmental affairs people supporting and being part of this, they would know the associations, but there's one for behavioral health centers. There's one for the developmentally disabled community centers. We call them all community service providers, even assisted living, and through SEDAHO. I think that that sort of education and sensitivity would make a lot of sense. Going back to Camio's question, it's interesting. I work with Sheila Woodward a lot in Yankton. And Sheila is like a lot of lawyers, does things for pro bono, especially for circumstances like this. But it's very clear what the reports require in court. And I don't know if that's true in each circuit, but there's always a provision in the report about how her health is and where she's currently living at Majestic Bluffs, and she's content there, and a questionnaire would be, we could probably elaborate on that with practitioners in the world, Cameo, to say, we should probably ask, have there been any discussions about palliative care or end of life dialogues? That might be Dr. Eisness is, piquing my interest. That might be a good trigger for attorneys in that practice.
So with that, I'm just looking at the statute you're referencing on that annual report, and it's kind of minimal to briefly state the medical, educational, vocational, and other professional services. But I like what you're saying would you see that as needing to be sort of a statutory expansion of defining, what requiring of medical, or maybe just in the training that guardians receive, that they have some sort of form that Dr. Eisness could help put together, that says, have you had these discussions, or flesh that out a little bit if you don't mind.
Just because I'm doing it on the fly, I don't know I'm a big fan, if I had to buzz in right now, of adding anything to a statute, because that's not necessarily going to be entirely followed. Versus if you look at the education piece, I didn't find it overly burdensome, but I don't recall anything in the education to get the certificate that, Matt, you should be aware of end of life scenarios and think that through and talk with your protected person's attorney about that. And, maybe then in practice, because the questionnaire that we're given, I think it's fairly standard. So every year, Sheila will shoot it to Karen and me, and we'll complete it out, or I'll call her paralegal and just say, hey, this is what's changed. She moved. She's now in nursing home, blah, 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 blah. And so it very well could be that we could ask in that questionnaire, and you could, be a great practice idea for the elder law group, maybe. So.
Yeah, thank you. And good answer on the fly. We won't hold you to it or anything, but I appreciate your.
Go ahead. Hey, Mari, how close are we to the world that you live in? Is there anything that you and your team from all your hard work together that I've missed or should elaborate on, or you want to add? Mary, are you there?
I don't see her audio here, so she may have to reconnect by audio.
Looks like you're muted, Mary, are you? Okay.
But we have other palliative care experts on the call. So any questions for Matt regarding guardianship? Maybe the challenges you're finding clinically?
Great.
This is Terry. I would say we are very fortunate to have the help of our ethics team. It is a challenging situation, as it seems to be more process laid out in Minnesota as compared to South Dakota.
Minnesota certainly does have a lot of hoops to get through. It seems like when discussing code status, a letter has to be written to the Minnesota Guardian and Department of Health about why it's medically necessary. So I know they're being very protective and cautious. Terry, I don't think we need quite that process for South Dakota, or am I forgetting that?
This is Michelle, and I'm helping with ethics. And we actually have recently written a couple of letters to South Dakota as well. However, we don't get a response. So in Minnesota, we send letters to the Guardian and we get a response. In South Dakota, we send letters to the Guardian and they pass it on to the next person about changing code status. But we, to the best of my knowledge, we haven't been unsuccessful in changing any sort of code status through that process. But they have been requiring letters.
Are those circumstances where the state is the guardian?
That is correct.
Okay.
That is correct. And also Minnesota has recently changed it so that if we ran into a situation, I don't know if it's changed or not, but a recent situation where there was basically an unrepresented person at all levels. And we wanted a guardian for them, but the state denied it because there was no abuse or neglect to that individual. And there was no documentation that they were unable to make decisions until we got them at this very unique point in their life. So even though we could prove a fact pattern as we were digging for a guardian or somebody, even a close friend, but we're unable to find one.
Yeah, not sure how to weave the way through that one. Matt?
Well, I think
Thoughts?
with, we have, and unfortunately, I predicted before we left office, I gave a couple of addresses to individuals in the great city of Pierre and other places that we are not going to have in the next 8 years from when we left, we're going to have a 25% reduction of individuals, for example, in Pierre. Obviously, you've got a lot of state employees in other areas. And it's very, very difficult to get people to do that kind of work. We obviously all in our organizations have problems recruiting. With that being said, it would seem to me that if the Department of Human Services and Social Services got together now with the money that is available for these type of things and re-energized and tried to figure out how we could streamline state guardianships. That would be something I think that would get support at various levels. You would get a concern coming from our people who manage these programs that we just don't have enough people. It'll be that difficult. And so you kind of work through that collaboratively. Money is not the issue. And I think that always shocks people whenever you say that. Money is absolutely not the issue. The issue is finding staff to continue to do that and prioritize, especially when you got a situation like Michel's talking about where they're stretched thin within human services, taking care of elder abuse now. And now we're sitting there saying, okay, now we've got to establish guardians for somebody who's really not in an abused situation. That needs to change. I would tell Shawnee, the secretary, that in a heartbeat, as well as the individuals who run social services, Secretary Gill. I mean, they've been through all of this. They're very, very compassionate people. So that's something that I would advocate for, especially with the kind of funds that we see rolling in from the feds and our economic largesse in our budgets.
This is Charlene. One of the things that I think about is goals of care conversation, and how does that fit in? So I think of it kind of a little bit more upstream. If we had the opportunity to have goals of care conversation with those guardians and the people that they're having that guardian over, could that help downstream as they get into those situations?
So we have, periodic care conferences with Bev Ann's care team, and there is a dialogue about that. Now, that's in a long-term care setting. We did that with her mother as well in the assisted living. I don't think it's, as they would say in seminars these days, hardwired in community support environments like group homes, but that would be a great outreach perspective, because a number of these group homes, there are behaviors, and they're dealing with neurology and everybody to try to figure out these behaviors and the appropriate medication. So I've always been personally frustrated in some of the group home circumstance with clients that we have lost that, I'll call it care conference bridge. And I'm sure that's an environment, and they're not necessarily required in assisted living, depending on what state you're in. In case you're on a game show, it's not even required to have a medical director. So for assisted living, which can be problematic, but I love that idea, Charlene.
I recently read an article about that 25% of the people entering the nursing home, this is done in Canada, had an advanced care plan completed. And what they thought, they surveyed to find out kind of why that was, because you would think that as you enter the nursing home, that would be one of those automatic things. And it was when they were talking about code status. And so the patient's family thought when they asked about code status, that was the advanced care plan that was done. And so there was that gap there. And it was just like kind of mind-blowing to me almost. So I can't even imagine in the other care settings and stuff. So.
When if I am interpreting a prior comment you made, Matt, I think it would be probably not wise to change it in statute, but somewhere could there be a rule, or maybe it's just education, that, there needs to be an annual report, but wouldn't it be best if the guardian actually went to a clinic appointment, and then the discussion can be made about maybe there's decline, maybe the person's aspirating more, to develop those goals of care moving forward, which, yes, clearly includes code status, but it could maybe be hospitalized or not rehospitalized, because we want to move all this discussion the upstream and not during crisis. And yet it does seem with many guardians that I worked with, it was during crisis. So I don't know if that's Cameo, if that's with your educational project, or if that's, since it's not in statute, but I think probably try not to put in statute, because that opens up its own problems. I'm speaking as a non-lawyer, of course.
I'm kind of trying to not get super excited about this concept. So I'm hearing the not in statute, which I agree, we've sort of went through that road just with most, and the difficulty of it, and I'm sure other places too that, Dr. Eisner's been a part of. So possibly what could be brought, maybe to like a lawyer education table with the elder law community, and or with those attorneys practicing in this area. So Matt, I guess if I can take Luann's question or comment and sort of tweak it, if you saw a place for a questionnaire type of document where, a guardian is given a format that says, have you had a goals of care conversation with the, physician or the attending physician, whomever that might be. And these are the things that you should look to have a conversation about, A, B, C, and D. If this LifeCircle group were to try to come up with that sort of type questionnaire, first, would it be useful? And then where would you best see that being used? Would it be with the attorney who oversees the annual report? Would it be in the education when you get your certificate for, being a guardian?
So one of my many deficits is my line of sight is that I've never petitioned for a guardianship and never taken on that responsibility in my law firm. It's always been, I've represented a potential protected person or have actually been the guardians, like the one fact pattern I've said. What I would suggest is that is a great idea, but I would get a hybrid of bringing in the association presidents and other people from the community service providers, because now the slice that I keep talking about are developmentally disabled individuals, which is obviously handled by that association, but you also could have the behavioral health organization for the state, and just put together a working group like we would with any other state bar, like a UCC group or everything. You brought other, what's the phrase, stakeholders together. And in this circumstance, Bev Ann, before she needed really any healthcare, Karen was the primary individual who would always go to annual conferences, which are required, like an IEP on steroids, when she was being cared for by Ability Building Services. And she had a work manager because she was working and all of those. And so you could really get into, have you had a conversation about her healthcare and her desires and goals with her tremors and those type of things, because all these individuals will have some sort of healthcare issue and see a parent, and they would be very accepting of that. I'm blanking on the association for the developmental disabled homes, but it'll come to me. And when it comes to me, I'll email it to you. But I think those worlds would mesh. And if Sheila's got that form, other practitioners have got similar. I don't think it was statutory, but she's relying then on me. It's just set up in their system and Karen to complete them, right? So that she's just submitting the report that we have attested to, Karen and I. So.
Are there other questions for Matt?
Well, it's been a great privilege to see and meet a number of you who I know your names or we've emailed. It's a real privilege, and especially through Mary. Is Mary, are you back on now? Let's see. Okay. But if there's anything else, or you want to do any other conferences, I learn more than I impart, I'm sure. I know. So.
Well, on behalf of LifeCircle, and I also thank you very much for taking an hour out of your day plus whatever prep time, because I learned a lot. And yes, it's good to have that group think as we move forward to help make, at least from a healthcare point of view, help the guardians make those decisions. And I think we've got some ideas, and Cameo, you'll probably want to collect all of us back together again and have some brain think about how we can educate, because a lot of people on this call would like to be part of the education. So this is recorded. We'll send a link out, send a link to you also, Matt, so that you can use this for education of students and other healthcare professionals. So thanks. We appreciate this a lot.
My privilege, and thank you for all that you care for, especially as the world gets more complex. The compassion of this organization, is powerful. And Justin, thanks for setting up all the technology. And getting the documents to people. I just take it for granted, but thank you.
He is our key guy. All right, may you all be safe and healthy.
Thank you.
Bye-bye.
Bye.